Hello, good night
Good
to all
night.
viewers of Legalize. We apologize. We had a little technical problems. The internet just dropped just as we were about to start. So sorry about that. And tonight we have with us Judge Deboarh Thomas-Felix. She is an attorney at law by training, trained at UWI and Heward Law School in Trinidad. She has advanced qualifications also in law from the United States of America, and she also has advanced qualifications in business. Most significantly for our purposes tonight, she is the former president of the Industrial Court in Trinidad and Tobago, and she is currently a member of the ILO, International Labour Organization Committee of Experts. Welcome, Judge.
Thank you. It's my pleasure to be here.
Yes. And I just want to say from the start that one of the sponsors of this program is Grenada Technical and Allied Workers Union, GTAO. So, in fact, they started the sponsorship at the commencement of the month. And as you know, this is the month of May Day, a lot of industrial matters. It's seen as the month of labor. I know in Trinidad it's slightly different, but that's a different conversation. So, Judge, we have seen a lot of interest in this program, and with you being tonight, we know there are quite a few people who want to follow. I hope that the technical glitch doesn't throw us off a bit. But we are here. So, Judge, I want to start on the issue of the industrial court, because there's an industrial court in Trinidad. As far as I'm aware, there's one in Antigua, but there's no industrial court in Grenada. I don't know if we can just speak for a while and hear you on the functions, the role, the powers of an industrial court, and your own view on the importance, and your own view on if you think Grenada is missing out on something by not going that way. I know it's a bit of a mouthful, but I'll ask you more questions as we go along.
Well, first of all, the industrial court, let's deal with Trinidad and Tobago. Unlike the rest of the Caribbean, Trinidad and Tobago does not have a labor code. Grenada has a labor code. Antigua, which has an industrial court, has a labor code. And all the other islands in the Caribbean have labor codes. The industrial court, the act in Antigua sort of mirrors the industrial court, the Industrial Relations Act in Trinidad. But the industrial court in Trinidad is a superior court of record. And what that means is that it has all the powers that will be bestowed in what you will call the High Court, which is your High Court. You have the OECS. So the powers which the High Court will have, the industrial court has it. So we will have the powers to grant injunctions, to have hearings, to deal with matters of contempt, etc., like a normal High Court. Now, with respect to countries which have code, and the code, the country, the parties to the country, they are bound by what is within the code. I'm aware that most of the codes have not been amended. As a matter of fact, I was brought in by the ILO a couple of years ago to give technical assistance in one of the territories to treat with their code and a possible establishment of a court or a tribunal. Now, a lot of the countries have either tribunals or something which is pegged and tied to the Ministry of Labor. So there is some way that a complaint could be made, but in most countries it ends at the Ministry of Labor. I'm aware that there are certain shortcomings in your code in Grenada. I can't remember all of it, but what I remember is that you are limited in terms of accessing a court. And I think in order to go to arbitration, you have to have the consent of the employer. But I can't speak much to that because I am not very familiar with your code. But I did read part of it when I was in Grenada 2 years ago.
Yes, so as regard non-essential services, you require the consent of all parties to go to arbitration.
Oh, I see.
And the code actually sets out the essential services, so that anything that is not an essential service is a non-essential service. So airport, telephone, electricity, water, all of these will be essential services, and all others are non-essential services. So,
in most countries, the essential services are spelled out in legislations or code, and there, the essential service speaks for itself. They are the essential service which the country relies on. But with respect to the question of whether or not Grenada should have a tribunal or a court, I did have conversation when I was in Grenada with your persons from your government 2 years ago, a year and a half ago. And I know that from what I gather, that some sort of consideration or deliberation is being given to that. So I don't really want to comment on that. What I want to say is that in every country, the whole aspect of social justice and the right to social justice and the importance of labor rights and human rights must be upheld. And that is basically the mantra of the ILO, that labor rights, human rights, and we say in the ILO that labor rights are human rights, that it must be upheld in terms of and adhered to, in terms of the machinery which you put in place to have those laws, that those rights upheld. That, I guess, is more for government to determine what is suitable for their own country. So a very long answer, but I think you understand what I'm saying.
Yes, you say that basically the realities of each country will determine
what their needs are.
But at the end of the day, there must be social justice, you say.
Yeah, and there must be some vehicle. There must be some vehicle to just sit and say that, first of all, a lot of these codes are outdated and ought to be brought up to this century. And to say that you have a code and there's no vehicle that person's rights can go to abeyance because there's no vehicle to take it further raises the question as to what is your how important is social peace? I haven't even gone to social justice yet to your country.
Yes, so in Grenada, as you alluded to, with regard to the non-essential services, there's a process in the Ministry of Labor. And if the matter is not settled in the Ministry of Labor, there are provisions to go to arbitration, but as we alluded to earlier, it must be by consent.
It must be by consent.
Both parties have to agree. So there was this case that went all the way to the Privy Council in Joe Williams versus Calabash Hotel, I think.
Yes.
And what happened there in that case was that the employee made the complaint of being unfairly dismissed, and it went through the Ministry of Labor. The Ministry of Labor ruled in our favor and made certain recommendations. Then it went before the Labor Commissioner, is the one who heard it first, dealt with it first, made certain recommendations. The employer did not accept the recommendations. So the next step in the process is you go to the minister. The minister then accepted the recommendation from the Labor Commissioner, and he made it as his recommendation. The employer again refused to accept that. So then there was one other step, arbitration. The employer said essentially, no, I'm not consenting to the arbitration. So it meant that the employee was left without a remedy for unfair dismissal, because both the Labor Commissioner and the minister agreed that the dismissal was unfair. So the matter went to the court.
To the Privy Council.
All the way, the High Court, Court of Appeal, Privy Council.
Yes.
And they all took the position that, listen, the court has no jurisdiction because the act that created the remedy, which they said was a new remedy, was a remedy not known to the common law. The act created the remedy, the act created the procedure, and they couldn't do anything about it. You know,
I think there was a question of part of it being unconstitutional.
You mean part of what?
At least someone told me that one of the things the Privy Council said was that one of the laws, I'm not sure which one it is, was unconstitutional and recommended that Grenada review its laws in this regard.
No,
I'm not sure. That's what someone told me.
No, they said it was inadequate, not
inadequate. Oh, I see.
That it provided inadequate remedies, and they lamented the fact that, well, you have a recalcitrant employer just says no, and the employee is left without a remedy because they said the remedies provided by the parliament are inadequate. Well, different people have different points of view. If you ask me, I don't think that was one of the better moments for our system, because I think it is recognized certainly on the European human rights law that where there's a right, there must be some form of remedy, and there must be final determination of the matter, one way or the other. So the employer was basically left hanging, told that you may have a right, you may have been unfairly dismissed, but ain't nothing the court could do.
So is there a movement to amend the legislation?
There has been no movement as yet to amend it. I don't know if the discussions about the industrial court is along that lines. But I'm taking it that something as that could not happen in Trinidad.
Well, with respect to arbitration, the industrial court has actually is the first court in Trinidad to have conciliation as part of its offering. And that came about with the Industrial Court, the Industrial Relations Act of 1972. So since 1972, conciliation has been an offering. Arbitration is something which is not offered at the Industrial Court, it's offered at the High Court. And there's an Arbitration Act, it's totally separate. But of course, all of them are alternative dispute resolution mechanisms, whether it's mediation, arbitration, or conciliation. And so at the industrial court, like your arbitration, conciliation has to be voluntary. You will ask the parties if they're interested in conciliation, and it must be voluntary. I would say to you that I am trained and certified in mediation, conciliation, and arbitration. And therefore I'm aware, unless, with respect to arbitration, unless the legislation determines that you must go, some legislation say it's voluntary, but when it comes to arbitration, some legislation say it is mandatory. In terms of mediation, and there's court annex mediation at the High Court, and that deals with family matters. And then there's conciliation at the Industrial Court, which must be agreed upon between parties. But if parties should say that they do not want conciliation, then it goes into the open court for trial. So there will be a resolution one way or the other. And in Trinidad and Tobago, when you get to the Ministry of Labor, if a matter goes before the Ministry of Labor, you're also offered conciliation at the Ministry of Labor. And when those matters fail, that is when they come to the industrial court, and the industrial court offers you conciliation again. And then it is up to you to determine whether you want to go forward or not.
Yes, but the point that I make, well, you have made the point that in Trinidad, if that matter, the Indra Williams matter, went there, then it would have gone to the industrial court.
Yeah, there would have been a resolution.
Yeah, there must be. But I think the argument, which is understandable, the fear and the concern is the clogging of the court system. If clogging, if every employment matter, every industrial relation matter can, the High Court has a jurisdiction, then I think the concern was really that you could clog up the system because you can have a whole heap of matters there. But that will only be so if the process in the Ministry of Labor fails. A, and B, I think it is also an argument for considering a alternative dispute resolution outside of the High Court that in any case will bring finality and have a determination of the matter. I think under the laws of
Africa, there are some countries that have alternative dispute resolutions annexed to court. So it's court annex resolution, where there is a completely different unit which treats with the conciliation and the ADR part of it without even considering the court. And a number of matters are determined in that way. So it removes the burden, so to speak, on the court and treating with those matters, and it can focus on the other matters which requires the attention of a judge.
Yes, I mean the OECS Supreme Court has that, so that there are many matters which commence by way of claim, by way of action, and then the court will send it to mediation. I think Grenada has been quite successful in that regard. But we're speaking here specifically about employment matters, in particular issues of unfair dismissal, where what comes out of the Indra Williams case is that the court has no jurisdiction with regard to those matters. And at the same time, with regard to non-essential services, you need consensus. You need all voluntary, both parties have to agree, which, as the Privy Council pointed out, is really a shortcoming, a serious defect in the system. So, for example, in St. Vincent, they are similar to us, but they don't have an industrial court. But my understanding is that the minister has powers in all matters to send it to mediation, or to send it to arbitration or some form of alternative dispute. So you don't leave the employee hanging. Because that could be a source of great grievance in any system.
What has been, and I shouldn't be asking, but I would like to know what has been the effect since that judgment. Has it been that more employers are refusing to consent? Has it been that there are more cases going to arbitration? Was there a consequence to that ruling in terms of how employers approach claims now?
I cannot really speak to that because I'm not involved as a practitioner in the labor movement, but I know of at least one case, quite an unfortunate case, in fact, involving a statutory body. That matter arose in 2017. They started the process for arbitration, and after about 6 years, following the ruling of the Privy Council, the employer then said, listen, I changed my mind. Basically,
well, that's what I was asking, if there was a consequence.
Yeah, that at least in that one case, I think there's a consequence. But that matter is still before the court on different issues. But I don't know, and I don't know if any of the trade unionists are following this program could indicate, but I don't have the impression that there has been just for any widespread consequence. But the potential for that is there, and maybe should be removed. So, in your experience, though, how regular was that jurisdiction used, the industrial courts? It's a lot of matters, or just
A
now
lot of
and then?
matters.
A lot of matters.
Well, the industrial court is a specialized court. So
Yeah.
the first step would be the industrial court. The act prevents a certain category of persons from coming to the industrial court. And those are persons who make policy. And that has been a sort of bone of contention, particularly with unions, because sometimes when someone is described as making policy, the person really is not making policy. And according to the act, if that is challenged, whether the person is a worker or not, it goes to the recognition board for the recognition board to determine the point of policy of worker. But I'm saying that to say those cases where the person cannot access the industrial court, they go to the high court via the civil court. However, all other matters come to the industrial court. So the list, the numbers of matters are quite a lot. And because of COVID, the numbers increased.
And that had to do with some effort to make the taking of the vaccine mandatory.
Well, you had vaccine matters, but apart from that, the whole question of leave, you had the issue as to how do you get leave? Do I use my leave? What type of leave I should use? Then you had health and safety concerns. Who should be buying the mask and the this and the that? The different health and safety concerns. There were a number of matters which flew. Some businesses didn't have sufficient resources to keep them going. Do they pay the workers severance? Do they not pay them? Do they pay them half pay? Do they work 3 days a week instead of 5 days? A number of issues arose in COVID. And as a result, a number of matters came into the court. A lot of parties, they resolved it through the conciliation system. One of the things I want to say, though, we encourage, at least when I was president, I encouraged parties to have bilateral resolution, where parties sit and meet and talk to try to resolve their issues even before they go to the Ministry of Labor. So sometimes a matter may come to you and you may think that this is a matter where you don't want to have any further fracture in the relationship. So you will ask the parties to go and meet and give them time to come back before they even see a conciliator judge. Now, some of them may say to you that, no, we need to get a conciliator, and we agree that we will have a conciliator judge to look at these matters. Well, those matters are separate, but I want you to know that there is bilateralism, because social dialogue is very alive in terms of the way the court functions. So you have all aspects of social dialogue there. You have bilateralism, you have conciliation, and the open court hearing is the final part. The court is the final arbiter in the entire thing.
Okay. Besides yourself as judge, president of the court, who has sat on the court?
Sorry?
How is a tribunal of the court comprised to deal with any matter? The president alone, or what?
No, the act provides, first of all, I don't know if you know much of the Employment Appeals Tribunal in England. I have to take my phone off. There's an Employment Appeal Tribunal called the EAT in England. I had the privilege of sitting in that court for 2 weeks, I think, or a week or something like that, hearing, sitting into matters and all of that. They have the industrial court in Trinidad has the same type of structure, in that in order to qualify to be a judge of the industrial court, you can be an economist, an accountant, industrial relations practitioner, or a lawyer. So the president of the court must be a lawyer who is qualified to be a high court judge or is a high court judge. The vice president of the court must be a lawyer. However, the other judges is a pool of whatever. So usually when I fix quorum, I normally look for different disciplines because no one will know everything. So I may have an economist on the panel. According to the type of matter, I may have an accountant. And the chair is usually a lawyer, but it is not always a lawyer. And so we sit in groups of 3. Sometimes I will impanel 5 persons according to the seriousness. And then I have never had one person sit. If you see one person sitting, it's because the other judges who were sitting previously might have left the court, because the act provides that if someone leaves, the others continue.
Okay, and how are complaints brought to the court?
So you can file, they normally go to the Ministry of Labor, the general complaints, general trade disputes. After 14 days at the Ministry of Labor, if there is no movement there, they can come directly to the court. And that was made through a high court, a court of appeal decision in terms of interpreting the legislation.
Mm-hmm.
Or the Ministry of Labor may have conciliation, and conciliation broke down. And so they send the matters to the court for hearing. Now, in matters of occupational safety and health, you do not need to get a union. You could only, normally you could only access the court through a union and employers. The court does not recognize individuals, unlike England. Okay. So you cannot come as an individual to come into the court. You have to get, you cannot even get a lawyer. You have to join a trade union and be a part of a trade union. However, in matters of occupational safety and health, you do not need to be a part of a union. You can access the court directly, and it is usually done through the union. However, there is nothing that debars someone from accessing the court without a union.
Okay, and do you, if
and I must say that there is an offense in the law called an IRO, Industrial Relations Offense. You can come directly, the union can come directly to the court, or the employer can come directly to the court and say, this person has breached and has created an offense. And so you would not go to the ministry, but you will come directly to the court.
Okay, as you say employer, just flag that. So both employers and employees through the unions mostly can bring matters to the courts.
Only unions and employers can bring matters to the court. Employees cannot bring matters.
Outside of OSH matters.
Health and safety. Other than health and safety, the matters are laid between unions and employers.
So I'm thinking now, we have, I know like in Grenada, I don't know if that exists in Trinidad, you have several workplaces which are not unionized. If employees there, they have an issue, what happens?
They join a union.
Would they join a union? So yes. even if the union doesn't have bargaining power rights, they just join the union.
You can join in rights matters. Now, a lot of people seem not to understand the difference. I notice when I say it, a lot of times people don't understand. So let me explain. There are rights matters and there are interest matters.
Mm-hmm.
If it is a rights matter, you can go to any union and any union can pick it up. If it is an interest matter, the place has to be unionized. in Trinidad and Tobago, it's called a RMU, Recognized Majority Union, which has bargaining power to represent workers of different categories and different bargaining units. One of the things you have to understand with Trinidad is that there is a, what you call that? There is exclusive, I don't know how to explain it.
Exclusive bargaining agent rights.
Huh?
Exclusive bargaining agent rights.
No, we have exclusive areas for the operation of unions. So therefore, if it is public servants, only one particular union, and the ILO normally, I always have to explain this every year because they have a problem in understanding it. Only one union could represent public servants. If it is water, once that union has the rights, okay. So I think you would know of OWTU because it's like the largest union in Trinidad. They represent workers in certain parts of the energy industry. So they cannot represent a worker in health. That is what I wanted to say. The unions specialize in particular areas.
Yeah.
And so most of them, there would be, of course, the ad hoc union, which doesn't have a specialty, but those ad hoc unions will not be representing in interest matters. Now,
So
if you're representing in interest matters, you must be the recognized bargaining unit and union for that organization.
Yeah, so just to highlight the distinction, I don't know if you can give me one example of what will be an interest.
All right, so when I say interest,
yeah,
if you're negotiating wages, salaries, cost items, benefits, those are interest matters, and only recognized majority unions, RMU, that represent, let's say it's the Water and Sewerage Authority, which delivers water, which is an essential service. It mightn't be the best example because they will have about 3 or 4 unions, because they will have a union representing the daily rated workers, a union representing the public servants. And you understand what I mean? Although it is one entity, you cannot represent all the workers. So if there are security estate police officers there, the estate police people will represent them. If there are public servants there, PSA, the Public Service Association, will represent them. If they are weekly and daily rated workers, the NUGFW will represent them. Now, so when you're representing these workers, you will be negotiating and doing collective bargaining for better terms and conditions and benefits for workers. For example, higher salary, maybe higher pension, whatever it is. Those are interest matters. And only those workers, only those unions who are recognized, it meant that they got recognition status through the recognition board. There's a recognition board, which I mentioned earlier. You must get recognition status. You must have a certain majority before the board even thinks about giving you status. And once you get status there, you will get a certificate, and the certificate will tell you the categories of workers that you will represent and those which are exempt from your record, from your union. And that is an interest matter. Rights matters are like, you dismissed me, you treated me bad, you discriminated, whatever it is. Those are normal rights matters where your rights are affected. Yeah.
Okay. And any union could represent you in those matters.
Any union.
Okay. So I was asking about employers. And
by the way, any union could represent you if there is no union, if the place is non-unionized.
Okay, I get that.
If the place is unionized, you cannot.
It has to be that union.
Yes, yeah.
I get that, yes. Okay. In terms of the matters coming before the courts, what proportion comes from employers versus those coming from unions?
You mean who is as the complainant?
Yes, the proportions as a
The
complainant.
vast majority would be the
Unions.
unions will be the complainants, because those who think that they have been wronged will be the workers.
Yeah, okay, good. And in terms of representation before the courts, you did have a lawyer?
No, not necessarily. The unions train their people, and they can stand and represent their own people. The employers have their HR people. They can stand up, and anybody can appear on behalf of their company or union and make the representation. I have noticed in my years of the court, and I have had many years of the court. I've been at the industrial court since 2003, and then I stopped for 2 years to be the head of SEC, and then I'm back. Then I came back. There's more of a movement now to have lawyers than before. It used to be a trade unionist who was trained, standing up, maybe a HR person or IR person from a company, and they will defend their matters and make representations like lawyers. Because of course, IR is a very skilled and specialized area. And therefore not many lawyers will be versed in IR or might be even be interested in IR. But I have noticed over the last 10 years or so, there are lots more lawyers practicing, particularly when the cases are big cases or cases involving the government. You will find that there will be lawyers.
Okay. So maybe we move over now to let me see. I'm seeing one or two comments in the chat here. Grenada needs an industrial courts. And someone is saying this is nice and informative program. Yes. So the ILO now, how does the ILO fit into this entire mix, and how did Miss Justice Judge Deboarh Thomas-Felix get into the ILO stream?
Well, as you know, if you were to look at a tree with branches, you know that the ILO is the trunk.
Right.
In the sense that the ILO started in 1919 after the treaty, as part of the Treaty of Versailles, after the World War I had ended. So it's the longest, it's 100 and something years old. And because of what was taking place at that time with workers being oppressed by the industrialized nation, they came together and had this mantra, which is still the mantra of universal and lasting peace, and that there cannot be universal and lasting peace if it is not based on social justice. And so the ILO had been there, and then of course the UN came in 1946, and we are where we are. With respect to, well, I need to say this. What people need to understand is that the ILO is the only specialized agency in the UN system. And it is very unique in the sense that there are 187 member states, and they come together, the unions, that what you call them worker representatives, the government, the employers come together, and they make labor standards. So they all sit together and come up with the conventions and the recommendations and the labor standards for the entire world to operate on. And the reason why this is unique is that they all sit in the room and agree that these should be the labor standards which the world should use. And of course, it is adopted and reduced into national law. And once you ratify the convention, it becomes binding, and all of that goes in there. With respect to me, I don't know. What I can tell you is that the head of standards interviewed, I was interviewed along with 5 other persons in the Caribbean to be on the committee of experts. And I can't say what happened, but I got it. Yes. So and that was in 2015. So I've been on the committee of experts since then. You may not know that there are lots of maritime and fisher convention, and in about 2014, all the various maritime convention, I can't remember the amount now, but it's like 80 something or 70 something, don't hold me to it. They put all the conventions together into one, that is the MLC. But we still have the Fisher Folk Convention, the Fishermen Convention, the Seafarer Convention. And anyway, they put all of them into one. And it is like it's very technical, very difficult, but it guides the whole of the world Marines fleet. And I, together with my friend from Greece and my dear sister from Panama, who happens to be the chair and whose origin is Grenadian and Trinidadian, the 3 of us, we are the maritime specialists, and we have been driving the whole maritime initiative since then, since I joined actually. When I joined, I sat with a South African renowned man called Mr. Professor Chidel, who developed all the laws for South Africa, Zimbabwe, and all of those countries there. And I sat with him and I did discrimination. And then the next year, the 3 of us have been doing maritime. And in 2019, I began, together with my maritime portfolio, which is huge, I started also to do occupational safety and health, because my Fulbright is in occupational safety and health and environmental law. So I have been doing occupational safety and health with a lady, a professor called Professor Zuri from Lebanon. And she and I treat with occupational safety and health. And last year, I started also treating with forced labor, because my colleague, we now have a new person from South Africa. And because I'm now considered old, I am assisting with forced labor. So actually, those are the 3 things I do at the ILO. But although I specialize in those things, all the others have their own specialty, and we come every day and sit in meetings every day from 3 to 6, sometimes 10 to 1 and 3 to 6, to discuss all the other conventions, so we can each give our inputs in the other ones that we are not specializing in. But that's basically the work. It's a lot of work.
Okay, so just to go back so we could be a little clear. Committee of experts, that's considered to be one of the, what I will say, the highest bodies of the ILO?
It's considered to be the prestigious body of the ILO, but we are the supervisory arm of the ILO. What we do is, there are 20 of us jurists from throughout the world, and what we do is that we ensure we are supposed to be independent, and we are indeed independent. So we come into Geneva every year in November, and we look at government reports, because governments must report on the conventions that they ratify. If it is right, let me explain. You have fundamental conventions. We have now 10, I will come back to your answer, but we have 10 fundamental conventions. There were always 8 fundamental conventions, but with COVID, 2 more fundamental conventions have been added. And so there are now 10 fundamental conventions. The 2 occupational safety and health conventions are now fundamental conventions. With respect to fundamental convention, there is a need for states to report every 3 years, and the other conventions, they report every 6 years. Now, although that is what is required, when we examine government's reports, we may think that something is not right here. And so we may request the government to report in a year or report in 2 years. So although it is not set in stone, that's what I'm trying to say. Yes. And so we examine, our role as the committee is to examine government's report, see where their laws are in sync with the conventions or not in sync, see where the practice and the implementation of the law is in keeping with the convention. And we also, in some countries, I notice the Caribbean don't do it much, but particularly in Latin America and Europe, the unions and the employers write to the ILO and give us their report and their version. So sometimes we have all 3 reports. So let's say it is a convention on discrimination, and the government will say, everything is good, there's no discrimination, we have this law here, you could look at that law here, we could look at that law. The union may write and say, well, there's a case of so and so and so. And the employer may write and say, there's a case of so and so. What we will do, we would get in contact with the government through a direct request and ask the government to give us more information on this matter before we make a decision. So we may give them a year or so to come back to us with something which we think is important. We also recommend to countries, the Committee of Experts, we also recommend to countries and offer them to take advantage of technical advice from the ILO. If we can recommend, let's say you are now putting in your new health and safety law, we can look at it and see that what you're doing is not in keeping with the conventions and certain parts are not strong enough, etc. The technical, in the Caribbean, there's a director in Peru, and there's the director for the Caribbean in Trinidad and Tobago. We can recommend as a committee technical assistance, and if you wish to take it as a government, we will make the technical assistance available to you, particularly when you're drafting laws, you want to make policy, you want to make changes. So that's a broad description of what we do at the Committee of Experts. But the Committee of Experts has been in place since 1926. And It used to be comprised of men, European men. Okay. And I'm told that in the 1990s, women came in. I'm proud to say my friend Graciela and I used to be the only 2 Black women there. And last year, a woman from Kenya came in. Graciela, by the way, I shouldn't be talking about her, but she is the first and only Black woman to rise to the position of Chief Justice in Panama. She's a retired Chief Justice of Panama. And
she's Grenadian Trinidadian, you say?
She's Grenadian Trinidadian. So although she speaks Spanish, she speaks fluent English. Yes. Yeah. And so she's the chair of the Committee of Experts.
Okay, great.
Yes.
I just want to go back a bit, kind of the first base, because you spoke about the ILO being an initiative coming out of the First World War, and an initiative of workers and people who wanted to protect the rights of workers.
I think the initiative was more of governments, because after the First World War, there was this movement towards having peace, and that the only way the world could go forward, because remember that was the time with the industrialization and the industrial where workers were being treated very, very bad. And they realized in order to go forward after the World War, that they must have social peace and social justice as key components to economic development.
Good.
And today, that stands. There you cannot have proper sustained economic development without social justice and social peace. And so from that, if you remember the Declaration of Philadelphia, which is the declaration of the ILO in the 1940s, which says that labor is not a commodity and it is not an inanimate object that you can treat like a television or something. Human beings work, and there's value and dignity in work. And so I think the world was going through some sort of change and internal revolution where the world was looking at itself and the way it was treating people and what came out from the World War. And then it was a question of what do we do? How do we have sustained economic development? And the only way you can do it is with social justice. And a matter of fact, the preamble to the ILO Constitution says that
Okay,
universal peace.
But
And let me just say this, and it just came in my head, and my head tends to overwork. If you look at the Philadelphia Declaration, it came just after World War II. And so this whole idea of having economic development, sustained and sustainable economic development, and having workers' rights being recognized and letting workers live in freedom and equity and dignity, that has always been the mantra of the ILO. And if you look at it now in today's world, it is still the mantra: decent work, conditions of freedom, freedom of association, freedom of organization, dignity, equity, security.
So I was going to ask, would I be correct to say it's a tripartite organization? That's the ILO. That
Yes.
employers are represented there?
So the ILO, there is something called the governing body of the
Yes.
ILO. The ILO has equal amount of trade unions, meaning workers' representative, employers, and government. I think in the governing body, the government has a little more. I think it's about 24 in governments, 12 employers, and 12 unions. But generally, in the 187 countries, all of them, it is employer, union, and government.
So it's a tripartite organization.
Yeah, that's right.
It's a tripartite approach. I only say that because just the name ILO and then what you said earlier could lead to the impression that it is like just an international committee or international union of unions, trade unions meaning, but it is a tripartite organization. It is part of the United Nations. It's a recognized agency under the United Nations with tremendous prestige.
And the work which is done by the ILO, all the conventions, all the recommendations, all of that is by the tripartism. The three of them must agree, must meet, decide we want to do this, we want to do that, and the world needs this and the world needs that. And they meet every year in the end of this month, in the early June, actually the first week of June this year, the 3rd of June. They meet every year. It used to be for 3 weeks. I think they now meet for 2 weeks every year to discuss things that they think is important. And at those meetings, the committee of experts report is tabled, and there's always ruckus every year. It's tabled. We would say, we would put our report as a book, and we also put something called a general survey. And if you did what you were supposed to do within that time, you will not be mentioned in the book, or you might be mentioned for doing great things. If you did not, there are certain things that we are concerned about as lawyers, as human beings, as members of the committee, what is going on into the world right now. And so we would write about those countries, what violations we think they have, what laws they do not have, etc. And this report is tabled every year at the ILC. It is the important meeting that people all over the world go to, except some of the Caribbean countries. Some of them don't go. But everybody tries to go.
I guess you won't be able to answer that, but it just running my mind. Why is that so? Because it appears to be.
I don't know. It depends on the emphasis. But if you're
the delegations will also be tripartite.
Sorry?
The delegations.
Yes, the delegation is tripartite. And the way the room is structured in the Palais in Geneva, I can tell you this, it's a very, very, very large room because thousands descend in Geneva. And the way the room is structured, you will see one area for unions, one area for employers, and one area for government all the time. And there are some observers towards the back of the room. The CAS, they call it, the Committee on the Application of Standards. And so we also have something called a general survey. We as committee members, every year we do a book called a general survey. This year it is on labor administration. That's what they're going to look at next month, the first week in next month. And what that does, you know, you may not know, but ILO is big on publication. If you want to find any data on anything, you just pull an ILO, right? So we do, while we are sitting as members of the committee, we are also working, well, not we, some of us are also working to prepare a general survey for each year. So there's a general survey which I am going to be part of working on in November for the CAS for next year. And so this year is labor administration, and the one next year will be medical incidents and medical accidents. Not sure I'm supposed to tell the world that, but that's what, so I have to go up before our committee meets to work on that, so that when the rest of the committee comes, they can get it, so they can critique it, go through it, and decide whether they agree with what we have put together.
Just as a question, which I guess many of the viewers and listeners asked, how were you able to manage being both the president of the industry of courts and on the committee of experts with that kind of workload?
Well, fortunately, I was granted, I would apply for permission to be out of the country at that time. And what will normally happen, well, since COVID, we do 1 week online here. During COVID, it was difficult because we were literally working here in this space. Mm-hmm. It has been very difficult and challenging. In the work that I do internationally, as you know, I'm a judge at the IMF. This work at ILO is literally the hardest work. I remember the first time I went into my office, and in those days, there's no COVID, and I'm very old school. So I told them I'm not working on any computer, I need files. So I saw these files going up to the roof, and I sat there, and most of the members of the committee, we work until like 10, 11 o'clock in the night. So I sat there until about 10:30, and I went to the hotel, come back, and sat, and then I was so satisfied. I had gotten rid of by the third, fourth day of the files. And then I came in on the Friday, and I saw the files just going back up to my ceiling, and I nearly cried. Because of the number of countries. But by now I'm used to it.
Yeah, we have some comments. One person is asking, how does the ILO treat with persistent violators of social justice?
Well, there are two things happen. If you have done something which is not in keeping with the convention, we would send something called a direct request, and we might recommend that you look at so-and-so, that you update your laws, whatever it is. And we can offer, like I told you, technical assistance from whichever country you are, because the ILO is in all the developing countries so that they can give technical assistance. And then you will send your report. And if it persists and it persists, then you go into our report that I tell you we lay before the CAS. Most countries, if not all, do not want to go in our report, and it becomes a problem. I think you know that, you may know that we had a mission just around COVID time to Venezuela because of what was happening in Venezuela. Because the Venezuelans had been challenging some of what we, the committee, write in our reports. Without getting into it, they had to send a mission to Venezuela. They've had to send people to Myanmar. There are certain times when it might be necessary for a group of specialists from the ILO to visit and have talks with the governments. But in terms of non-compliance, some might take a while, but generally most countries, I think because of investment and all of that, they try to comply because they don't want to get into our report because it's tabled and laid for everyone to see. The direct request, when we send direct requests for you, it is only between the ILO and the government. But when you get into the report, it's there for everyone to see.
Mm-hmm. So in other words, they don't want to be the bad books of the ILO.
That's correct.
As you see. There's another comment here. Jerry Kangali, or this person Kangali, recently said in an article that workers must depend on themselves.
That what?
Not the industrial. Jerry, I don't know if you can just post it. Yes. Recently said in an article that workers must depend on themselves and not the industrial code. What are your views on this?
Well, I cannot have a view in the sense that I think that comment is directly related to my departure from the industrial code. Okay. So maybe you might have to comment on it.
Yeah, fair enough. And someone else is asking, can you comment on the right to work in some of our constitutions in the region?
The right to work?
The right to work. I think you have it in the Constitution of Grenada, Guyana, Belize. They are in the Constitution.
Well, so the person is asking, freedom of association. Most constitutions have freedom of association as well. The whole notion of work, is more than getting a paycheck. Work is about people build social lives, they socialize and work. They, of course, get their wages, they help their families, they have their pension, they have their whole livelihood depends on work. And my comment with respect to the right of work, it is not only the right to work, it's the right to decent work with dignity and equity. And I think somewhere along the line, in some of us in the world, I don't want to zero into anything, we miss the memo about the dignity and the equity at work. People must work in an environment where they feel respected, and they must also work in an environment where they feel protected. And it is the duty of the employer to uphold the rights of the workers. I say it in court all the time, that in the employment relationship, there is a common purpose. And that common purpose is for your business to flourish and to thrive and to earn plenty money. And the common purpose with respect to the worker is to do a good job, get a good wage, so they can maintain their livelihood, pay their mortgages, their cars, and etc., etc. Both parties have the same common purpose and common interest to make sure that this organization flourishes. Therefore, what prevents you from treating someone with dignity when they spend how many days, how many months, how many years building the business and making the business a success? To me, that's a no-brainer.
Mhm. And of course, in
But
one
there
or
are
two.
some questions they can't ask me because I may reply.
Okay.
Okay.
I was saying in one or two of the companies acts, certainly Grenada, some others, they actually place a duty on directors.
They what?
There is a duty for directors not only to consider the interests of shareholders, but also the interests of the employees. That's exactly how that works out in
That's
terms of
laudable.
duties. Yes.
No, but that's a laudable provision.
Yeah. And additionally, more and more, I know that Antigua, they speak about it a lot. Speaking of, and that's, I think some people say it's the rationale behind severance pay, for example, that workers actually have equity in the business.
Yes, yeah.
Yeah,
There's
because
a lot of argument on that.
yes.
And
So,
all of that has to do with that you must have decent working conditions and work and have equity and security and dignity at work. All of that has to do with the ILO mantra.
and somebody who you may know also says, I agree it's the duty of the employer to provide a safe environment for employees. But what about child labor in certain countries? How does the ILO deal with this issue?
Well, the ILO, each convention, okay, let's look at maritime. There is an age. There's an age. In some legislation, it's 16. In Trinidad and Tobago, so there's, if you look at maritime, there's light work for a particular age group, and then when it goes beyond the age group and they become like 18, then whatever. But when it goes under that, it is not acceptable. I don't want to call countries, but we have had on several occasions to write and to request governments to rethink some of their legislation or the lack of legislation to protect children. But the ILO treats it very seriously. And each convention, when it comes to that type of, there's a minimum age convention, as you know. And then within some of the conventions, there are provisions for certain ages, light duties, and all of that. Now, that presents a challenge in certain parts of Africa where they say to you that the children are used to going out and helping their parents or whoever in the field and all of that, and it is not labor because it's family business and all of that. But I don't want to get into it. If you get one of our reports, you will see how we view and how we treat with that. But the ILO is very clear about minimum age and minimum and child labor and forced labor as well.
Yeah, someone is asking through message to me if ILO publications online.
Yes, you can access them on the website online, and
they are free or if they are free.
Huh?
The person wants to know if you need to pay a fee or if they are free.
No, you can go and download it.
Yes.
The PDF, you can download it. Also, I am sure in terms of Grenada, you would have, I don't know if you know the new director, but I'm sure if you contact the local office here in Trinidad, they will be happy to send whatever publications, because the ILO is big on publication and it's big on training. So you can get those publications free.
And someone has also commended you for having taken a strong view during COVID regarding the responsibility of employers to recognize contractual rights. So
Thanks.
somebody was following their work.
I think that when there is crisis, knee-jerk decisions should not be the first reaction.
Yes, that's true. And there was quite a bit of that during that crisis period.
What I will say to you during COVID, I was doing a serious amount of work here for the ILO because of the seafarer problem. What people will not know is that ships couldn't come to port. Nowhere. Ports were not allowing ships to come to port, and a lot of people were dying on ships. Some people who had been on vessels and have been on vessels for 2 years, 2.5 years for COVID. Some of them need food, and it was very, very difficult. And that is why the supply chain still hasn't been rectified up to now. The supply chain, the world supply chain went crazy. And so the IMO, which is the International Maritime Organization, reached out to the ILO. And the three of us, my two friends and I, we had to sit and prepare what they call the judgment, but we had to prepare guidance for the entire shipping industry to steer the shipping industry during COVID. And it required a lot of work on my behalf. And I'm the English speaker, so I had to do the writing as well. And what happened though, looking at the health and safety risks and all of that, I thought it was very natural for me to speak on the topic in my country because of the amount of work I was doing internationally, and it was accepted internationally. The Director General was going all over the world and calling my name and congratulating the kind of work we were doing. The IMO received it. So I just thought it was so natural to speak about it in my country. In any event, the year after, that was 2020, 2021, we did a follow-up to it. And therefore, you might find, if you are signatory to any of the Fishermen Convention, when we send our direct request to you or we report on you, you will see a clause to the top of it from us last year saying, further to our general observation of COVID-19, we expect that you will do so and so and so. So if you see a report on Grenada and you see that, that is as a result of the two releases we had, a very extensive one in 2020 and one in 2021.
Yes, okay. Can you just speak a bit to, let's say, speak to the tripartite, the parties, in particular in the Caribbean here, in terms of the benefits to be derived from more active participation in this island process? A little bit of advocacy.
When we look at examples around the world for tripartism, the two main countries that come up is Singapore and Barbados. Strange enough. We have places like, yes, and Barbados. Barbados has a system, I think, from 1991 or 1992, which has worked when they were going through crisis, when all the countries were going through these financial crises. That was what Barbados resorted to steer the country back to, to being stable. Now, tripartism is extremely important and alive. If you look at like Costa Rica and a lot of these Latin American countries, they have tripartite models and system, and it's working very, very well there. I would say that the importance of tripartism I do not know how to express how important it is, and I have said it to unions in Trinidad, it is important for everyone to be sitting at a table and have an equal voice in the room to determine development, economic development, social issues, social development for a country. To have one party make a decision, not knowing how it is going to affect the other two, really will be antithetical to development. In order to have serious, sustainable development, social progress, and social justice, all partners must be in the room, particularly on national issues and issues which are very important and affect the lives of citizens. And to me, that, in my mind, and I say it with the greatest respect, in my mind, I think it is a no-brainer. Because why won't you want to be in that room to determine your life, your neighbor life, your country life, your grandchildren life, and whatever? Why won't you want to say, this is good, this is not good? And why won't you? What has been happening is most models around the world have afforded labor and employers to have an equal voice in the room. If you do not have an equal voice in the room, and there is no one bigger than the other in the room, if you do not have that equality, then you will not have much success at tripartism.
Yes, I think if Barbados and Singapore, these are.
Yeah, Barbados. You should read the Barbados history and the model.
Yes, yes.
I can tell you about it because I did research on it a couple of years ago. And the Singapore model, you also have Costa Rica, where they have lots of things going on there. Lots of the Latin American countries have been embracing tripartism because of they have some very deep problems which could only be resolved, especially with those large populations, with the coming together and having a say.
Yes, you have a comment here saying, very powerful and knowledgeable woman. Great example for a junior person like me within the labor movement to look up to. It's probably
Thank
somebody
you.
you know. Yes, yes.
Thank you.
So, Judge, we have a few more minutes before we end again. I want to just recognize the Grenada Technical and Allied Workers Union, TAU, for the part sponsorship of this program. Thank you, TAU. There is another comment I just want to Jessica Adams, Honorable Judge, I commend you on the excellent job you have done in your role as President of the Industrial Courts. Over the years, you have indeed raised the bar, pun intended, so high that it is impossible to fathom that the bar is even remotely attainable. Thank you for your excellent service to our country and by default, the global village. And I guess right to our country there, she means Trinidad, but we also know you are also Grenadian.
Yeah, thank you.
Pursuant to our constitution. That your parents are from here, right?
My parents are Grenadian. My mother and father. My father is from River Sally and my mother is from Birch Grove. I think it's Birch Grove, right?
Yeah, Birch Grove, correct.
Birch Grove, yeah.
Yes, that's correct. Okay.
So I'm first generation Trinidadian.
Yes. Mm-hmm. I saw there's a Martin Strong question. Just we can take it because it was there. Is there any relationship between the ILO and the WTO?
No, the WTO is the World Trade.
Yes, and the ILO is the International Organization.
Yeah, but of course they're all international organizations and will always link, but the ILO will be under the umbrella of all the UN organizations.
Okay. Any closing words, Judge?
Well, first of all, I want to thank you. I'm traveling tomorrow, and I was like, oh, but I really enjoyed the time I spent here with you. I thank you for having me. I thank you primarily on behalf of my parents and my ancestors to be able to share and give back to Grenada. So that is more important to me than anything else. So I thank you for that. I think if we had to continue traversing economic development and sustainable development in the Caribbean and in the world, it is very important for us to understand, and I think we don't do it in the Caribbean, the need for unions. I say if you do not want a union, you will need to speak to each one of your employees individually and get buy-in from them. So if you can do it collectively, talking to one person or two persons, obviously it is easier. But it is also important for unions to understand employers' rights and for employers to understand their duty and responsibilities and workers' rights. It is better to sit through collective bargaining and have social dialogue and resolve issues than resorting to come into courts. Courts are not friendly places. They are not nice places. And sometimes if you don't use the ADR system, one person will win and one person will lose. So it's better that parties come together. I tell people in court, I am not going back on your work with you. You are going to go back. And therefore, if you fracture that relationship, it's going to be difficult to pick up the pieces than if you sit. And I know Senator Lewis, that's the only labor person I know very well in Grenada. But you have collective agreements. In your collective agreement is the grievance process. And that will be a bilateral negotiation that parties sit and agree to. Go to your grievance process, follow the grievance process before you think of going to the Minister of Labor or your labor commissioner. Try to have social dialogue as much as possible. That I believe is the only thing towards economic progress. Social peace.
Okay, Judge, on behalf of all the viewers and on behalf of Legalize, we really want to profoundly thank you for this presentation and for being here tonight. Thank you very much. Good night, everyone. Bye.
Thank you.
Okay,
All the best.
Bye.
Bye-bye.